So, good morning, everyone, and welcome back to a weekly webinar series. Over to Anil, sir.
Thank you, Ankit. Today, welcome to 124th episode of AAA Weekly Webinar Series. The most important thing today is that Mr. Debajyoti Ray Chaudhary, the Managing Director of NESL, the company, the public sector company, which is presently operating the information utility, sole information utility in India. Although the provisions are saying that there can be multiple information utilities in India, but for the time being, this is the only IU in India. So therefore, we are pleased to introduce Mr. Debajyoti Ray Chaudhary, the Managing Director of NESL. Thank you, Mr. Chaudhary, for joining this webinar. And
thank you.
I hope your presence in this webinar will actually be very, very like kind of learning for all our participants. As you know, the importance of information utility is increasing in this insolvency as well as general uh, information, financial information, which can be disseminated to the public at large. So, Mr. Jyoti, at the beginning of this, I will just take this liberty to ask you the question: how do you feel the importance of IU is changing? One in IBC and the other is the general information dissemination.
Yeah, first of all, thank you, Mr. Goel, for having me. And also congratulations for having this series of webinars. And it is the 124th in the series of webinars. So it's a good initiative we are taking to impart learning on a voluntary basis. And the numbers are increasing. Participants who voluntarily joined on a Saturday for a duration of 1 hour. Now, information utility, of course, is a very unique institution, and the code provides for submission of information. It also provides for submission of documents. And in the recent amendments, I mean, we'll talk in detail in the later part of the webinar, what are these amendments. And the recent amendments aim to further reinforce and strengthen the role of the information utility in ensuring that admissions take place in a timely manner. Now, here, you also asked me to talk about what are the other things which you are doing. Now, initially, when we started submission of information by financial creditors like banks and also operational creditors, so the provisions also had provisions also stated that documents could be submitted. But then we realized that document submission was proving to be a challenge. For one, documents were kept separately from the information, which usually was flowed directly from the CBS system of banks. Also, scanned documents was extremely cumbersome way of having in digital forms, and also the legal enforceability of scanned documents is not really there. So that's why we launched this document execution portal where documents can be executed. So this was for the larger financial services sector. We don't know which company will go to insolvency. So document execution platform is there for each and everyone. And today we have almost 90 lakh documents which have been executed on the platform. Much of it is in the retail segment, but we also have in the corporate segment. Idea is that when at all insolvency needs to be initiated in respect of these entities, so both the information and documents are readily available in a digital form. And digital form means it is signed, secured, stored, and can be accessed in a digital form and in a manner which is enforceable and valid under the Indian Evidence Act, which has recently been replaced by a new law from 1st July. So these documents are valid and enforceable in digital form, and we are storing this in a digital form in a way it can be straight away used in a court of law or in a judicial proceedings that were brought to the CLT. So idea here is for the IU to build scale. Whatever we are doing for the larger financial services sector. So document execution, as a further corollary of that, we have launched e-bank guarantees. And all these, whether it's document execution, whether it's data, whether it's bank guarantees, will be useful to the insolvency professional in the corporate insolvency resolution process, and also while facilitating admissions under the corporate insolvency resolution process. Now, just one aspect I'd like to dwell before I hand it back to you. We have seen a record number of resolutions in the last 2 years. In fact, this year also, going by whatever we have done up to June, I think we may be able to exceed the records we achieved in the previous 2 years. But one aspect still remains, and for which data is not really there in the public domain, as to how much time it takes for admission of a case into insolvency, into corporate insolvency. So that's one area where a lot needs to be done. First of all, the data itself is not there, but we all know as practitioners that it does take some time. And so that's where I think the present regulations of IBBR are aimed to help that the record of default should be conclusive proof of default and help the take a firm decision as to whether there is default and corporate insolvency resolution process can be initiated. Now, one caveat here is that as part of this process, the period taken to issue the record of default by the information utility would increase. But the entire thought process behind this is that even if it takes more time for the information utility to issue the ROD, the delays at the time of admission at the stage of the adjudicating authority, the NCLTs, can be reduced. So I think that's about it. I've tried to sum it up, and I'm able to find it for the clarification.
So thank you, Mr. Chaudhary. We'll come back to you for very, very specific questions so that we actually understand from the regulator, like I would say the person who actually is handling the entire operations of IU. We would be able to understand many things from you. See, basically for my participants, I just want to give little introduction that this information utility concept was introduced in the Insolvency and Bankruptcy Code. Section 3, subsection 21 defines the information utility, which is defined as a person registered with IBBI under section 210. And section 210, in fact, provides all the details of the information utility, what would be its obligations, and who all would be the users for this. So basically, like information utilities, in case we have to just define in a very, very small, like kind of a paragraph, then we can say this in the IU are entities that act as data repositories of financial information. Now, the financial information is also defined, which would receive, authenticate, maintain, and deliver financial information pertaining to a debtor with a view to facilitate the insolvency resolution process in a time-bound manner, but it is not restricted to only insolvency resolution process. It is otherwise also would be, or in fact are working as a platform which delivers financial information about an entity. Now, when we see the insolvency law, in fact, is basically, it was right from the beginning, it was said that the insolvency law is having 4 pillars. So the 4 pillars, in fact, what was created out of this particular law was, one is the insolvency professional, and that also includes insolvency professional entities. And the second pillar was a new institution by the name of information utility, which we are talking about today. And then the third is NCLT and DRT. For individuals, it is DRT, and for corporates, it is NCLT. And the fourth is the IBBI. These are the 4 pillars which actually is supposed to be, it was created by IBC. Now, we have like the information utility is primarily the primary sections which are approved by Parliament of the country is the Insolvency and Bankruptcy Code. Then the regulations which are issued by IBBI for regulating information utilities. Then as far as these compliances are concerned, this is all like the regulator for IBBI, for regulator for IUs would be or are IBBI. Because see, presently there is only one IU in India. As I said, there is a provision that it can be a multiple IU scenario over a period of time when public at large will start thinking that information utility is actually a very important database for taking business decisions. Then there may be multiple IUs that may come and the IBBI may approve them. And then these IUs are guided by one IBBI and also the information utility technical standards. These are basically various. So in fact, there are various sections in the IBC which actually is talking about information utility. When we see section 3, subsection 9 defines about the core services that will be rendered by the IU. Then the definition of information utility is also provided in section 3, subsection 21. Section 7 also says that the record of default can be attached along with the application under section 7. Section 9 also says that the record of default which is issued in Form D by IU, that also can be attached. Then regarding section 17, 18, 36, like the RP or the liquidator, they're all kind of guided that you can get information from IU about debtors, about assets, and also about liabilities. Even for verification of claim, section 38 says that the liquidator can in fact verify the claims based on the records of default or financial information available with IU. Similarly, the preferential transactions, in fact, the insolvency professionals are guided that you can even find the related parties information from IUs. Similarly, so there are various sections, section 210 that we've already said how to register. So like what we are now trying to say that like in case we just find a little bit of what about the basics of the IU. Basics of the IU means the one, in fact, how to use IU. In fact, the regulation 18, see, like we are not even discussing today how to form an IU and how the IBBI is regulating IU. We are also not discussing how the IU has to comply with various regulations issued by IBBI. What we are only trying to see is something which is important for users of IU. So first, regulation 17, in fact, defines about the services of the IU. What services IU would be providing or are providing. So there are core services. So these core services, in fact, has been again defined by the IBC. Then other services under these regulations in accordance with the code. So then there is again, the information utility shall comply with the applicable technical standards. So I think the technical standards are also issued by IU, and that is issued by IBBI, and IBBI is regulating the IUs based on technical standards, and IU is also supposed to function as per technical standards. For a user, now for example, that I have to use the information available on IU, then I would be required to register myself on the information utility. I would submit information. After registration, I can even access information, and that is like I see this is the basic requirement of using IU. Then the IU will verify the identity of the person and the information provided by the person that would be verified, and a unique identifier is issued to a user. Then once a person is registered with one information utility, then he is not required to register. Presently, I'm not, in fact, I'm only trying to say that there is a possibility of many IUs. So I'm not deliberating on those provisions which is applicable only in those circumstances then when we have more than one IU. I'm not discussing. So one important part of the usage of the IU is like, for example, the State Bank of India is having the one account as State Bank of India. So they can also appoint a authorized representative to carry on the activities like to submit information or to get information. That is that your staff can also do the functions after getting it registered as a user. Information utility, in fact, has to maintain a list of registered users and all the unique identifiers and all that they are supposed to do. Now, see, like I'm not discussing because see, there are many things that, in fact, see, one amendment was here on 14th of June 2022, and when this new regulation 1A was inserted in regulation 20, so it said that the before filing an application to initiate CIRP under section 7 or 9, as the case may be, the creditor shall file the information of default with the IU, and the information utility shall process the information for the purpose of issuing a record of default in accordance with the regulation 21. Now, Mr. Chaudhary, here is something which is important, because now when we file a section 9 application, the first requirement is that we should actually submit the information to IU and then to get a record of default in Form D. I just want you to deliberate on this because this was an amendment on 14th of June 2022, and even after that, we are making it applicable for section 9, but for section 7, we are not doing it. So this information, what is this practical part of it, we would like to understand from you, Mr. Chaudhary.
No, this 21A is applicable both under section 7 or 9. And see the way the regulations have been notified. So it says that before filing an application to initiate CIRP under section 7 or 9, the creditor shall file the information of default with the information utility. Now, in this context, IBC has also issued a clarificatory circular. So, quoting these regulations and also the NCLT order, and it is said that information of default should be filed, and as a good practice, we can attach the record of default to the IU. So, let me just clarify: Section 7 remains. So, you can use the record of default or any other evidence as provided under Section 7 to establish default. But since you are, availing the services under the code, it'll be helpful if you could use the record of default, and more so because record of default has been specifically designed for use by the AA. So it has all the components which the AA requires to establish default and admit a case into corporate insolvency resolution proceedings. So whatever the AA requires to establish default, for example, there's a cutoff of 1 crore. So the amount of default. And since IBC was also concerned that what happens if there's a dispute. So in this present regulations also propose that especially in the case of financial creditors, that is banks who are under Schedule 2 of RBI Act. So in those cases, if a dispute has been filed, so it is the responsibility of the IU to see whether the dispute has been, there's a valid proof of the dispute. And in case the valid proof is not there, then the dispute will not be accepted. So that is one part. And the second part also is that if the dispute in respect of a non-financial information. So in that case also, that dispute will not be accepted as far as issuance of record of default is concerned. Again, I will go back to my original statement. The idea here is that reduce the time for admission. I mean, issues like, amount of default. So all this can be decided later. At the time of admission, the AA has primarily to decide whether 1, there is debt, 2, whether there is default, 3, default is above the cutoff limit of 1 crore for initiation of corporate insolvency, and also whether the limitation law is still valid to initiate corporate insolvency. That's why if you see the present regulation, the proposed amendments also talk of acknowledgement of debt. So the idea here is that we'll capture all the essential requirements which the AA requires to decide on whether there's a default and admission is to be done. And coming back to your original question, whether it's mandatory or not, as of now, no, because Section 7 remains as it is, Section 9 remains as it is. But the idea is that if you have an instrument which can help in establishing default, which can help in the A in taking a decision whether to admit an institution, an entity in corporate insolvency resolution proceedings, the market should decide that this instrument is efficient, this instrument is effective, so we should be using it.
So
right?
One which is important for all of us to understand, I think there is a practice as of now that the registrar say that you also submit Form D along with your application under Section 9. Is it the correct practice, or my understanding is incorrect, or some of the registrars are asking and some are not? What is your
So I don't have any feedback on that, but I can tell you what the law says. The law says you have to submit information to the information utility before initiation default. And also I would refer to again Section 7, which says that you can use the record of default and you can use any other information, and what else you can use, that also has been specified in the CRP regulations. But I'll again come back to my original statement. If you have an instrument which is effective, which is efficient, which can save time, which can be of benefit both to the applicant and to the A, so why not use it? And this is coming from an institution which has been specifically created under the provisions of the IBC.
So like when I see this, when I see Regulation 20 of the IU regulations, before filing an application to initiate CIRP under Section 7 or 9, as the case may be, the creditor shall file the information of default. So does it mean like this is still not mandatory even if we have the word as shall file the information record, or does it actually means in case your transaction is registered, then you must file? What exactly this means?
So I'll clarify again. Maybe I'll be very emphatic now. Firstly, filing information of default is mandatory, but as Section 7 says that you can use record of default or any other instrument. So attaching with the record of default is not mandatory. But having said that, as I said, IU is an institution created under the provisions of the code. It can make your life simpler. It can make the process of adjudication by the institute simpler. So it's always advisable, efficient to use such an instrument, which has all the requirements which the A needs to establish default. Yeah.
Now I think like I need to reach out to the authentication of default, which is Regulation 21 of IU regulations. Like the information utility shall expeditiously undertake the process of authentication and verification. Now I see there are amendments in this regulations on 13th of August 2024. The first is for the purpose of this, the IU shall deliver the information of default to the debtor seeking confirmation of the same within 7 days. Deliver the information of default to the debtor seeking confirmation of the same within 7 days. Now, this is the amendment now, like in case we see this earlier it was as specified in the technical standard. So what was specified in the technical standard? Before this?
So it was, it was specified as per, the technical requirements of the situation. But now it is clarified here that it is 7 days across all periods. So
7 days
overrides, it overrides everything which is provided in the technical standards. And what it effectively means that the original message. After that, 7 days, you have to give a reminder, and each reminder will also be followed in the space of 7 days each. Now, since you've asked me this question, let me just elaborate on this. The question which would be naturally coming in everybody's mind is, why did this require a change? And would it not, lead to more time being taken to issue a record of default? So the answer to questions is, question one is, why did we change this? Or why did IBBI change this? The idea here is that default is quite a significant development. And we need enough time for the debtor to ponder over it, look at opportunities even for negotiation with the creditor for regulation. And also remember, for the debtor, as you yourself mentioned initially, for the debtor to authenticate it or even dispute it, he has to come to the information security portal, NESL portal, register, and only then he can authenticate. So that's why adequate time is being given for the debtor to ponder over this issue, whether he would like to do some out-of-court settlement, whether he would like to use other resources to repay the debt and to ensure that insolvency proceedings do not proceed from there on, and also take whatever steps which are required by him to register, because sometimes authorized signatories may not be there. There's a change in authorized signatories. If it's a company, we need a board resolution. So all those data and information, legal requirements are there to register the information. So we are giving adequate time for the debtor to come forward and decide as to how to deal with the default. If he wants to do a settlement, he can take it up separately. If he wants to register, we are giving him adequate time to come to the platform, register, and give his views on the debt. Now, the second part of the question, which I thought would be relevant for all your listeners, will it take more time to issue a record of default? Yes. As per a rough estimate, earlier it was 3 days each. So a record of default would ideally be issued in, say, 3 reminders in 3 days each, plus leaving a few days gap, maybe 14 days, you could have a record of default. Today, it will take almost 32 days. So will it take more time? Yes, it will take more time. But why are we still doing it? Idea is that the record of default becomes more robust and becomes acceptable, because now the IUs are also required to examine the documents related to debt, documents related to default, documents related to dispute. So all those documents IU will need to examine before issuance of a record of default. So in that sense, the record of default will be a very robust document, and it will become more acceptable to the AA to establish default and decide on initiation of corporate insolvency resolution procedure. So it will take more time at the IU end, but it might reduce time for the AA to decide on admission. Yeah.
No, only here it's a very, very specific question which is coming from the participants. They are saying, like, if I'm giving an example that suppose today I decide to proceed against a person under Section 9, and that transaction has never been reported to IU before today, then like my first thing is that I should submit the information of the financial transaction and also the default. Then I wait for 32 days, and invariably the other person also knows that I am now trying to proceed against him under Section 9. So he will definitely submit a dispute. So what is your advice? Because see, one side, Section 8 says that you will have to give a 10 days notice to the operational creditor before you file application under Section 9. And in case there is a dispute on record before the issue of the notice, that actually would be considered as a dispute, and then that application would not be admitted. Now, so first of all, my participants are, in fact, they would be happy, they would be very, very careful that first there should be a notice under Section 8. Then we should start the process of obtaining a record of default. Otherwise, this record of default, which we are trying to take, the other person will submit dispute. And if you issue your notice under Section 8 after this, so this may be considered as a record of dispute on public domain, and that too before the issue of the notice. So whether that particular dispute is genuine or ingenuine, of course, that will take longer time. So in case you have to endeavor for taking record of default, first issue notice under Section 8 and then try to register the transaction on or register the information of default on the IU after that. Am I correct, or I have some wrong understanding, Mr. Chaudhary?
See, let me straight away address one fundamental issue. As far as operational creditors are concerned, if there is a dispute, then it has to be adjudicated by the AA. So the IU will have very little role if there's a dispute by the operational creditor. The only role for the IU is that if there's a dispute which is reported, the debtor will have to upload the supporting document. But as far as dispute is by the operational creditor is concerned, in any case of dispute will need to be adjudicated by the information. So that's a subtle difference in this proposed regulations. But as far as dispute by banks are concerned, yes, because banks have robust documentation, and most of the cases, the issues like supply, quality of material, other things will not be there. So there, the regulations say the IU will decide on whether the dispute is one of non-financial nature or not, and also divide the information in two parts, whether it's disputed, whether it's not disputed, and issue the information issue the authenticated record of default for the non-disputed amount, and also for the disputed amount based on the information submitted by the debtor. If we find that the dispute is not acceptable, the documents are not sufficient to establish dispute, so then notwithstanding the submission or the recording of dispute, we can still issue a record of default with the authenticated status. So to answer your question in short, for operational creditor, if it's a disputed, so it remains disputed as it is, IU will have no role in that. But having said that, I mean, let us not always presume that in every case it will get disputed. So let's give this law a chance.
I'm only trying to say one thing.
Our records, our experience says that all the information which is submitted, disputes as of now also are still not very substantial. So let us never presume that every case is likely to be disputed.
No, like, see, I'm only very, very specifically, in case I have to issue notice to the operational creditor before I file Section 9 application, that notice has to be before. Otherwise, the other party will submit a dispute on IU and will say that I have issued, there is a dispute on public domain before the notice is issued to me. So this is a caution that definitely I would like to say that Section 8 notice must go before the transaction of the record of default is like kind of effort is being made to get that. Otherwise, because this will take 32 days and 32 days are enough for kind of replying for two times or three times he has to reply. So all the three times he will record a dispute, and whatever form D would be issued, that also would be shown in kind of a red color. So now, see, what is the impact of this increase in the time, 32 days as against 14 or 15 days earlier? Now it will take 32 days to obtain a record of default. But as you said, that now this record of default will actually have more authentication. Is that true? More authentication? Yeah. Because this
it's not a question of more or less. It's a question it'll become more robust, because now the record of default which we are issuing will be duly examined by our end, and also the debtor will be given adequate time. And in fact, let me just also give a caveat here. When I say 32 days, it is the outside limit, right? And even before that time, if the debtor accepts the default, so that record of defaults can still be issued. Even before that time, if the debtor accepts or does not accept it and put a dispute, and we find that the dispute is not valid, it's not acceptable, and this is only for banks under Schedule 2. So in such cases, again, the record of default will be issued before 32 days. So 32 days is the outside limit. But again, I would like to, state once more that most of the amendments in the August 13th regulations are in respect of banks under Schedule 2 of RBI Act. The provisions remain to operational creditors and others by and large remain the same, except that before issuing a record of default, we are still required to examine all the documents like debt, default, and establish the authenticity of the same before we issue the record.
So I think now, in a brief manner, I would also say, like, in case you want to get a record of default, the first is that you submit the information about the default to the IU. IU will actually will send it for the confirmation of the debtor, and that information will go within 7 days. And then in case the debtor doesn't respond, then the reminder will be, at least 3 reminders will be sent to that debtor, and those reminders, in fact, those reminders would be sent to the debtor by hand or by post or by electronic means at postal departments or by email. And then this is the step 1, and the step 2 is like the information utility can also kind of get some more evidences from MCA record or CERSEI or even any other repositories. And then, in fact, if this information is submitted in Form C by a bank, which is a bank included in the 2nd schedule of the Reserve Bank of India, then this is also an amended part. And what is the importance of this amendment, Mr. Chaudhary, when we have seen that like at a couple of places, the wording, which is a bank included in the 2nd schedule of the Reserve Bank of India, has been added.
Yeah. So first part, I just like to clarify, this 7 days is for the debtor to respond. See,
Yes.
our system is automated.
Right.
So the moment you send an information, so almost instantaneously the mail will go to the debtor. It is not 7 days for us to send the mail. It is 7 days for the debtor to respond. Our sending a mail is instantaneous. Now you made a very important point.
Let me read this regulation, because I am reading this regulation 21 sub-regulation 2. For the purpose of sub-regulation 1, the IU shall deliver the information of default to the debtor, seeking confirmation of the same within 7 days.
Yeah, so basically what it means is that we have to send it immediately, but the debtor has to respond within 7 days.
And then again,
seeking confirmation within 7 days. That means
yes,
he has to confirm within 7 days. It doesn't mean that I am given 7 days time to send the mail. Seeking confirmation within 7 days means he has to respond within 7 days.
So that means this 7 plus 3 reminders of 7 days each.
Yes, yes.
That makes 28.
And plus the originals, so 28 and one day gap in between. So that's why we are calculated roughly 32 days.
Yes.
Now, one important point here is, you said about MCA and CERSEI. So MCA and CERSEI, the only reference to we are making is for the seeking the email ID of the debtor. That is just to ensure that tomorrow the debtor may not say that this email ID is not mine, or this email ID I have not received any email. So we are using only the MC email ID and the CERSEI email ID. CERSEI we don't have access right now. We are using only MC email ID. Now, here there's a subtle difference between the treatment which is to be given to debtors whose information is reported by banks in Schedule 2 and those for others. Now, in banks in Schedule 2, we are supposed to use, we have been, as regulations say that we will use 3 mail IDs, Form C email ID, debtor registered email ID, and MCA email ID. So that is for debtors whose information is submitted by banks. Now, in case debtor whose information is submitted by operational creditors or any other institution other than Schedule 2, then we are required to use only 2 of them, which is MCA email, debtor registered email ID and MCA email ID. Now, this is a very important provision which IBBI has brought on. They have made this change. Why? The reason is, if some creditor, for a malified intent, he gives a wrong email ID In fact, he can even give his own email ID in the Form C email ID. And assuming the MCA email ID and the data registered email ID, data registered email ID may or may not be there. And MCA email ID also somebody does not use or does not respond, or it's not valid. So in such cases, an ROD which would have been issued where the debtor has not been given an opportunity to respond. So that is why for creditors who are not banks in Schedule 2 of RBI Act, the provision of using the Form E email ID has now been removed. So clarify once more, for anyone other than a bank in Schedule 2 of RBI Act, we are required to use only two email IDs, which are the debtor registered email ID if the debtor is already registered, if the corporate debtor is already registered. And secondly, the MCA email ID. So only these two email IDs, and if the creditor himself has provided email ID in his Form C, so that email ID we will not be using for the purposes of delivery of information to them. I think this is a very important change which has been brought in to this amendment on 13th August.
So that's really helpful. And then whenever you issue Form D, that means the record of default, you also provide the status of authentication. Now,
Yes.
the status of authentication is provided in different colors. So when when the debtor confirms the information of default, then it is considered authenticated and the color would be given as green. When the debtor disputes the information of default, then the status of the authentication will be considered as disputed and it will be marked as red, like the Form D was marked as red. And when the debtor does not respond even after 3 reminders, then it will be considered as deemed to be authenticated and that will be marked in yellow. So this is the status of the authentication whenever the Form D, like the record of default, is issued by the information utility. Now, then there is another amendment, like if the when it is for banks, then there is a table 2 which is now inserted. In that case, there are only and only two status of authentication. One, where the debtor confirms the information of default, or where the debtor does not respond even after 3 reminders, that will be considered as authenticated and not as deemed authenticated, and that will be issued in green. So the yellow, as far as these banks are concerned, wherever the banks are there, then the yellow is considered to be eliminated out of the status of authentication. Is that correct, Mr. Chaudhary?
Yeah, absolutely. That is absolutely. In fact, see, this was already there. This provision was already there for banks in Schedule 2. But in the amendment, something interesting has been proposed for banks in Schedule. So what has been proposed is that there's a concept of non-financial information which has been brought in. So the debtor, if he disputes some non-financial information has not been defined under the code of the regulation. So we'll have to see how do you interpret this non-financial information. But the regulations now provide that if for a bank in Schedule 2, the bank submits information and the debtor disputes the information, says that it's non-financial information. So in such cases, notwithstanding the debtor disputing it, the record of default will still show as authenticated. So this is a very important provision. So if it's a dispute related to non-financial information, notwithstanding the debtor disputing it, will still be treated as green or authenticated. And of course, this is only for banks in Schedule 2. Now, there's a second interesting amendment for banks in Schedule 2. So there, the debtor is given an option to accept part of the information and dispute the remaining. And then in such cases, he has to give the documents in support of the dispute. And IU will examine those documents. And of course, he will be given adequate time to give supporting evidence. And if the supporting evidence is not sufficient, so notwithstanding the debtor disputing the transaction, it will still be treated as authenticated.
So why this provision is applicable with effect from 1st of December 2024?
Yeah. So the reason which is done, because see, we must appreciate that IU is a completely automated process. There's a lot of technology involved in this, and to ensure any kind of errors. So the entire process is system driven and automated with very little manual intervention. So these time periods are given because this is a very complex development where complex logic has to be applied by the system, because there's to be part dispute, part authenticated. So these are very, very complex software developments, and there's no manual intervention. So adequate time is being given to have all the systems in place. That is one. Secondly, if you see, what are these documents to establish debt? What are these documents which are to establish default? What are these documents to establish dispute? So these are no standard documents are laid down anywhere. So this time period is being given so that some kind of standardization happens, and we can arrive at some kind of consensus among stakeholders as to what kind of documents this could be to establish debt, to establish default, to establish dispute. So what are these documents through which these events could be established? Because in the event of non-centration, so documents of different types would be submitted, and this could lead to disputes or disagreements. And also at the AA level, also it could be come into scrutiny as to what kind of documents has been used to establish each of these events. So basically, the time is given, one, to establish the various documents required to so that they become proof of happening of each of these events, and also to have the systems in place so that it can be a completely automated and straight-through process.
So I think this is really helpful. And another amendment, since the time is also like going very fast, so we are only having 10 minutes. One amendment which probably just a kind of regulation 21 capital B has been inserted with regard to dissemination of public announcement. And it is saying that the information utility shall disseminate every public announcement it receives or has access to on the date of its receipt or access, as the case may be, to its registered users who are creditors of the corporate debtor undergoing insolvency proceedings under the code. Now that I mean that whenever you get access to any public announcement, and you would actually be issuing the alert, you would be issuing the alert to the all those creditors who have given loan to the corporate debtor. Is that correct?
No, I'll just clarify this. In fact, this is not something new. In fact, only earlier it was 21A, it has been shifted to 21B.
Yeah.
So basically what it means is that this public announcement which we get in respect of made by IP, so this we disseminate to all the creditors of the IP, of the CD. So basically when the IP uploads a public announcement on the portal of IBBI passes on this information to us through an API, and we use this information to alert all the creditors of the debtor that corporate insolvency proceedings have commenced, and please do submit your claims to the IP. Now, what is the purpose of this? Purpose of this is that sometimes the public announcement is made by the IP in the newspaper, of course, and their requirements of where it should be published. But despite that, we have many instances where creditors do not file the claims. And as you know, there are many judgments which has gone right up to the Supreme Court that after approval of resolution plan, no further claims can be accepted. So this leads to unnecessary litigation. And just to avoid this, we are advising all creditors right at the time of commencement of CIRP that look, CIRP has commenced, public announcement has been made by the IP. Please do submit your claims to the IP. So this is it is just to ensure, one, that all creditors are alerted and they submit their claims on time to the IP. And this we are doing to support the IP and to also ensure that all creditors are aware and they don't need to resort to litigation and later on date to see that the claims are get admitted by the insolvency.
See, one, Mr. Chaudhary, recently we have seen that couple of insolvency professionals during CIRP, when somebody files a claim, they are sending letters to them that please also submit the record of default. Is there any change that even for filing your claims you have to submit this, or is it somebody is doing just out of their own creation?
No, I'm not sure why this has happened, but record of default is primarily to establish default for the purposes of admission of CRP by the adjudicating authority.
So while Ankit is trying to understand what are the important questions regarding IU, like Mr. Chaudhary, is there any other amendment that we have missed out, or you would like to say anything about any other amendment dated 13th of August 24?
I think broadly we have covered it. So I think broadly we discussed, I think, yeah, go ahead.
So let me ask a few questions that might be
Yeah.
relevant. So first of all, I think the most important question that is coming in, that NESL, of course, is providing a very major technology and it is behind this entire process. But the question that people ask is that if somebody disputes an amount, then who adjudicates that dispute? Who then says that no, this is disputed, this is not disputed? Because disputes can also be frivolous, disputes can also be erroneous. So let's say, like, as a protection measure, a company says or instructs its management that whoever files any entry in the IU, you please dispute every transaction. Let's say it says a blanket, gives a blanket, decision to the employees of the company that you dispute every transaction that appears in the IU against us. So what do we do? How do we deal with that situation?
Yeah. So first of all, as I said before, let us not presume this, because as I said before, as of now, this was always feared, but as of now, if you see the number of cases where disputed asylum is still not many. But notwithstanding that, the present regulations have addressed this issue in a very, very comprehensive manner. So to start with, in the case of banks, if he disputes it, then he has to give the supporting documents for the dispute. And then if the supporting documents are not good enough, he can give subsequent documents again within the 32-day period. And if that within the 32 period, if these documents are still not sufficient to establish the dispute, in that case, for banks under Schedule 2, the dispute will not be accepted, and notwithstanding the fact that the dispute is registered, the information utility will still be empowered to issue a record of default with the authenticated status. I think that has been made very clear. And this is there in regulation. In fact, the verification part is 21A, the last part in it. I'll just read that out, and so it's very clear here. In case of financial creditors, which are banks, including second schedule of the RBI Act, information shall issue a record of default with the status of authentication as disputed for the default amount for which evidence has been received and verified, and issue a record of default with the status of authentication as authenticated in respect of the balance default amount. So it will be distributed only when the default amount for evidence of dispute has been received and verified. So it will be treated as disputed only if it is received and verified. And one more thing, let me tell you, even if it is not a bank under Schedule 2, today the law makes it mandatory for everyone. If he's recording a dispute, he has to give a supporting evidence. So, if a person tries to do this kind of blanket, this thing for everything I'll dispute, so then he has to produce evidence, and he will be responsible for producing any evidence if it's not found to be reliable or not supporting the dispute.
Understood. So the dispute, the evidence has to be added, number one, and that evidence also has to be verified. The verification you're saying will also happen at NESL. That yes, is the documentation that has been given to raise the dispute enough, or is a prima facie okay or not? Understood. I think this answers.
But the second part is only for banks and distributors, to clarify.
Understood.
It's not for everyone.
Second part is only for banks for now, but yes, for others.
But I
for
agree
others,
that
perhaps
the first part is also important. You cannot simply dispute. You have to give the evidence for the dispute. I
Understood.
think
So
that
the
is also
dispute
very
has to come
important.
on record, and then once the
Yes.
dispute comes to the court's attention at a later stage, let's say, and the dispute is raised with frivolous grounds, then
Yeah.
that can also be thrown in the bin. So
Yes.
this is what we're
Yes.
concluding then.
Yes. Yes. Yes.
That
He has to
really
give the
helps.
supporting evidence. And one more thing here, all information with the information it is with the digital signature. So tomorrow he cannot deny. And when he registers, he also identifies.
Right.
So he is fully accountable for any action which he does on the portal of the information. And there's an entire audit trail to establish that.
Understood.
So
So
he cannot, take back what he's done or, refuse to be accountable for what he's done on the portal.
understood. So then we're looking at another question from Mr. Hari Prasad. He says that can an IP register with IU as user
Yes.
for the purpose of
Yes.
create? No, he's talking about a separate thing. He says that he wants to register as a representative of the CD, and then he wants to register or rather register the defaults with respect to the company's dues against other creditors.
Yes,
So
of
he
course he
can
can.
also he
That's a,
can be
it
an
can,
authorized
yes,
signatory. So he can of
absolutely,
course
absolutely.
access the records of
Yeah.
IP.
Yes,
He can also make new
yes.
records.
No,
So
in fact,
this is
Ankit, this is a very good question. Excellent question. And I'm using this platform to advise all IPs. When you are in a CIP and you are finding some debtor is not paying, please do use this portal. You can register in fact, we have a very simple process for IP registration. You just give your order and we'll register you and I give you access to all the records and information. If any of your debtors are not paying, yes, you can file information of default in respect to the debtor. And believe me, you'll see how it works.
But then what is the important, Mr. Chaudhary, is whether the insolvency professional is supposed to register in the name of the CD and then make himself as an authorized representative, or he
So, yeah, it
can.
becomes by default. By default, it becomes authorized representative. The moment he gives the order appointing him as the IP, he becomes by default the authorized representative.
So, like when this, suppose I register myself as Anil Goel and I would be getting a user ID. Now I am, in fact, say I am handling or Ankit is handling 5 assignments. So in all the 5 assignments, so when I have to record of default, I have to just register. Then how do I change corporate?
This will be separate user ID for each of your assignment because see, the assignment is based on your appointment as IP. So it is not in a personal name. It is in the name of a CD.
So
As
the registration
of the
is
CD, you'll get access.
the registration is CD wise.
the registration would be CD, and I would become authorized. That's what, in fact, the person who asked the question, he rightly said that we register as CD and then we register ourselves as an authorized representative.
Yes.
And then we can register all the records default.
Yes. It's a very simplified process of registration.
Yes.
And almost more than 700 IPs have already registered.
All right. Okay.
But not many are using this platform for recovery of their debts. So I would encourage IPs. This is a good question, and this is very interesting that an IP has thought of this. This could be a very, very potent tool to to recover the dues of the CD in which you are the IP.
Understood, sir. Understood. So then, of course, there's a question which where Mr. Veer Pandyan is asking that he's appointed as an IRP in the matter of a PG, and then he says that can I get access to the CD's information? I don't think so.
You can. Yes,
as a personal guarantee. No, but he's not the insolvency professional for the CD.
He can. Yes.
All right. So in case a personal guarantor to a CD is under insolvency, the IP for the personal guarantor can also get information of the CD.
Yes.
Okay. Interesting. All right. I was under a different impression. I think with that the questions are taken care of, and I think
we also have. In fact, our research team has also seen many judgments. Right, the judgment of Kolkata High Court when this NCLT issued an order that all applications also should be having an attachment of record of default. So that was also held to be not mandatory by Kolkata High Court, and then also by NCL 80 and various other NCLT benches. So present scenario, as clarified by Mr. Chaudhary, that although it is helpful, although it reduces the time of admission of CIRP, but still it is not mandatory because there has not been any change in Section 7 or Section 9. Is that correct, Mr. Chaudhary? And I think with this we can...
it's correct. Yeah, and one final concluding point I would like to make, So the idea is that the market should decide what is effective or not. That is a more effective way of ensuring compliance and usage of an institution rather than simply make it mandatory. The market should realize the efficiency, the effectiveness, the utility of an information. So that's the intent, rather than making it by law and making it compulsory for everyone, or the full force of the law compelling someone. Rather, I would say that it's the market forces should determine whether it's useful, whether it's effective. And today, I think it is useful, it is effective. You have seen many judgments which have used the ROD. So I would encourage all to use the RU, try it and feel the difference.
So one last thing, do you think that you are going to get some competition? Any other IU is getting registered, or people are interested in getting the IUs registered or not? Or you would be still acting as a monopolistic IU?
See, first of all, we are certainly not a monopoly. So, like I said, and you yourself said, the regulations provide for registration of multiple IUs. So we are definitely not a monopoly. And, see, competition works both ways. Competition also helps developing the market. So I really have no views. If anybody, any other institution gets registered and wants to compete, wants to, function as an information utility, I will only look at the positive side. Because if there are more than one institution, like today I'm doing this advocacy on behalf of an information utility. So there'll be one more institution doing this advocacy. So it will only help the, developing the market and develop the institution. So we should think more in terms of institutions rather than specific companies.
So I think with this, we conclude our session. 124th episode is concluded, and thanks to Mr. Chaudhary for joining this very, very important discussions. Thanks to the participants. And as we always say, is that this is our way of learning. See, we are a full-fledged insolvency consultancy firm. And in case you have any query, when we upload this video on the YouTube, you will find our email in the description. So you can reach out to us for any further query. Thank you very much. Thank you very much, Mr. Chaudhary.
Thank you, Mr. Goel. And, I really appreciate this initiative you have taken to, to disseminate information and knowledge among the larger community. And of course, it was my pleasure to be part of this webinar.
Thank you. Thank you.
Thank you.